Watch it till you put that fork in your mouth, then it come around. Is everything okay? Okay, are you ready? Okay, call the meeting to order. Okay, welcome everyone. Thank you for being here. First order of business is the roll call. I'll start to my left with Ms. Point.
Nancy Ford, Roger Still.
Michael Green, Johnson City.
Norman Hall, Brentwood.
James Wade, Jackson.
Jason Covington, Nashville.
Edward Barola, Johnson City.
Rosie Johnson, Paris.
Okay, next item on the agenda is to adopt the agenda. Do I hear a motion?
So moved.
Second. Got a motion, second. All in favor, say aye. Opposed, likewise. Carried. Okay, new members. Do we have any new members? Jack Wade is a returning member. Welcome, Jack.
Well, I'm here
And,
temporarily.
Jason, I'm not too sure whether we formally welcomed you last time, but if not, we're glad to have you aboard. Okay, has everybody had an opportunity to review the September Commission meeting records? If they had, do I hear a motion to approve?
So moved.
Got a second?
Second.
Second? Discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Okay. The next item is the report of experience interviews, and we'll start with Nancy Point.
I had Mr. Steve Gregory, and I would like to ask that we approve his experience credits.
We have a motion. Do we have a second?
Second.
All in favor say aye.
Aye.
Opposed, like sign. So moved. Next one, Mr. Covington.
Yes, sir. We interviewed, along with Mr. Wade, Commissioner Wade, Robert Ashburn, and we'd like to move to approve his experience records, or his experience, or his reports to upgrade from licensed to certified residential.
Is that from trainee to certified residential or
That'd be
licensed?
correct.
Okay.
Sir.
Trainee to certified residential?
Yes, sir.
Okay. All right. Have a motion to hear a second?
I'll say.
Motion and a second. Discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Mr. Michael Green.
Yes, sir. I interviewed Nathan Edward McBroom, who was requesting an upgrade from trainee to certified residential. And I've asked him to submit more reports covering the income approach and also revisiting the cost approach. So at this point, I would make a motion to not do the upgrade.
Second.
Okay, we've got a motion and a second. Discussion? Hearing.
Just so that when I write the letter of request, you want 2 additional appraisal reports?
I had told Nathan 3
3?
income approach reports,
Okay.
and then also 3 reports with the cost approach that are dated after today.
Can they be demonstration reports if they don't have actual assignments?
Yes.
Will a second interview be required?
No. And he's expecting to submit that to you, Ms. Avery.
Okay.
Is that all?
That's all the questions I had regarding that.
Okay, back on the motion, all in favor say aye.
Aye.
Opposed, like sign. Like to recognize that Mr. Herbert Phillips from Nashville has joined the commission meeting. Welcome, Phillips. Thank you. All right. Dr. Barella?
Thank you, Mr. Chairman. For the education report, we only have a few items this month. First is course number 1609, Environmental Hazard Impact on Value, 7 hours continuing education. I would recommend for that course. And then 2 individual courses by Regan Schwartz and those, each were 10 hours. And I would recommend for both of those. And then, of course, by Mr. Lewis, 33 hours I would recommend for that course as well.
Okay, we have a motion. Do I hear a second?
Second.
Made motion. Okay, a motion, second. Discussion? Hearing none, all in favor say aye.
Aye.
Like to say approved legal report. We have an attorney with us this morning. Get my paperwork here. Healy,
Yes,
is it Braid, Baird?
it's Baird.
Baird, okay. Apologize for any
That's okay.
mispronunciation there, thank you.
Okay, I'm gonna go through this with you guys, but because I'm kind of new with you, I think I should just start. Number one, is matter 2012003281. Complaint was filed by a property owner and alleged the respondent misreported the square footage of the subject property, misreported comparable sale information, and undervalued the subject property. The respondent indicated he made some typographical errors in the first report. He did not complete the cost approach on the subject property because the secondary market of the client did not require it, and because cost figures do not always represent contributory value. The respondent indicated he measured the subject property using ANSI and Fannie Mae guideline requirements. He indicated the revisions to the report did not warrant a change to the value conclusion. And the reviewer conclusions consisted of the following. Physical characteristics of the subject property were not properly identified. Do you guys want to read? Okay. The alleged violations were SR 1-1B, SR 1-2EI, SR 2-2BII. The sales comparison approach analysis and conclusions were not adequately supported. The lack of support reduces the reliability and or credibility of the conclusions presented in this approach to value. And the alleged violations are SR 1-1A, B, C, SR 1-4A, SR 2-1B, and SR 2-2B, D, I. The next one is the site value and the cost approach exclusion were not adequately supported. The respondent has not correctly employed recognized methods and techniques. Alleged violations are competency rule, scope of work rule, SR 1-1 ABC, SR 1-4 BI, and triple I, SR 2-1B, SR 2-2 BII. There was insufficient information presented to enable the client and the intended users to understand the report. The analysis, reasoning, and conclusions are not conveyed in an appropriate manner. Alleged violations are SR 1-6B, SR 2-1B, SR 2-2B, BII, and the work file was incomplete as it did not contain the original appraisal report. And the alleged violation is ethics rule record keeping. And as you can see, we've listed the prior disciplinary history there. So the reasoning and recommendation would be, the reviewer found that the inconsistencies throughout the report diminished the reliability of the report. The information provided and the opinions reported in this appraisal report do not provide adequate support for conclusions rendered. Based on the evidence presented, it would appear there is a discrepancy in the reported gross living area of the subject property, and that this discrepancy could have an effect on the value conclusion presented. The appraisal at issue was performed in 2011. At the time, the respondent had been certified a residential for 13 years. The allegations as noted above are significant, and the value conclusion was not developed in compliance with applicable standards, thereby reducing the credibility of the conclusion. As such, counsel recommends the imposition of a civil penalty in the amount of $500, a 15-hour site evaluation and cost approach course, and a 15-hour market analysis and highest and best use course to be completed within 180 days of execution of the consent order. The civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
Do you recommend also that this continuing education or the education courses also be used for continued education or not?
As it reads, the 21 hours could be credited towards continuing education. If they take it online, then only 14 hours on credited.
We have the recommendation. Do I get discussion? Anybody have any comment, discussion? If not, do I hear a motion to approve?
So moved.
Second? Got a motion, second. Any discussion? Hearing none is approved. Next.
Number 2 is matter 2012011921. This complaint was filed by a home retailer and alleged bias in the appraisal of manufactured housing, use of inappropriate comparable sales, omission of subject property amenities, and undervaluing a residential manufactured house. This complaint was based on 2 separate appraisals of 2 separate property addresses, and the effective dates of the 2 reports were in December of 2011. The respondent states that the purpose of this complaint seems to be to try to influence the appraiser's value in the past and in the future, and that the complainant would not have had a problem if he'd gotten the number value he wanted. The reviewer conclusions for the first property address, the alleged conclusions are missing information on contract and asking price. Contract section does not list the asking price, even though the seller, per the report, is paying a large amount of closing costs and added several appliances as part of the sale price. Okay. We'll need to send violation numbers. Number 2, the neighborhood section was inadequate as it used very canned statements and very little real information about the neighborhood and area. There were no site value sales, no analysis of appraisal methods or techniques for site value and reconciliation. There was no explanation as to why the income approach was not appropriate, and there was no work file submitted. And for property address number 2, the reviewer conclusions were missing information on contracts and asking price. Contract section does not list the asking price, even though the seller is paying a large amount of closing costs and added several items and upgrades as part of the sales price. Neighborhood section was inadequate, with very little real information about the neighborhood and area. There were no site value sales, no analysis of appraisal methods or techniques for site value and reconciliation. There was no explanation as to why the income approach was not appropriate. Cost approach below sales comparison with no explanation, and there was no work file submitted. Recommendation: the reviewer found the report to be complete and credible and without bias, though there were careless or negligent errors in the report. The respondent was requested to submit the work files and all appraisal reports for the 2 properties identified in the complaint in May of 2012. To date, no work files have been submitted by the respondent, and a prior version of one of the appraisal reports was not submitted with the response letter. The respondent indicated that it would be burdensome on him to hunt down the boxes that contain the work files. The respondent has no prior discipline. Counsel recommends the imposition of a consent order imposing a civil penalty in the amount of $500 and a 15-hour residential report writing course to be completed within 180 days of execution. The respondent should additionally be required to submit the work files for these 2 assignments upon execution of the order. The respondent may receive continuing education credit for the corrective education. Civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser and protecting the interests of the public.
Do I hear a motion?
Move to accept.
Do I hear a second?
Second.
Got a second, discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign, motion carries. Proceed.
Number 3 is matter 2012005401. Complaint was filed by a consumer and alleged the respondent overvalued a residential property and exercised unethical conduct as a real estate appraiser, and that respondent offered to change numbers around to make the appraisal better. The respondent states that the property was very unique, larger than average site size, and had a desk home. The respondent states that the agency informed him to proceed and use the best sales information available, in which he did. The respondent states that he offered the complainant a partial refund when he found out that no one would take her loan. The respondent also states that the allegation by complainant that he could change numbers around was completely false. The reviewer concluded conclusions were, previous transfers were not reported and/or analyzed. The report indicates that the subject has not been sold nor ownership transferred over the past 36 months. Per MLS and tax records, based on the review's research, that the subject property appears to have transferred twice within the last 3 years prior to the effective date of the report, which was October of 2011. Relevant characteristics of subject improvements and the effect on value have not been adequately discussed. Site value support is not provided in the report or the work file. The cost approach analysis was not supported. Fiscal depreciation was not properly calculated. And the work file submitted did not contain 2 copies of the appraisal report submitted to the client. The reviewer found that the appraisal report lacked sufficient information to enable the client to understand and rely on the report and did not submit true and correct copies of all appraisal reports communicated to the client. The respondent has been licensed for 13 years. As such, counsel recommends the imposition of a civil penalty in the amount of $500 and a 15-hour residential report writing in case of discourse. Civil penalty should serve as a sufficient economic deterrent, while a corrective education should assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
Do I hear a motion?
I move to accept.
Okay, move to accept. Do I hear a second? Got a second. Discussion? Hearing none, all in favor say aye. Aye. Opposed, like sign. Motion carries. Proceed, please.
Number 4 is matter number 2012-005451. This complaint was filed by a consumer and alleged that respondent undervalued a residential property and that the respondent does not know his job. The respondent states that complainant claims that he did not have a basement. However, respondent claims that while not all the way below grade, the complainant did in fact have a basement. Respondent states that complainant's accusations that he did not know what he was doing are baseless. Respondent states that he sees his complaint as an obvious attempt to illegally influence respondent's value opinion based on the hypothesis that the subject below grade level is completely above grade, which is untrue. The reviewer conclusions were that the site value support was not provided in the report or the work file. The cost approach analysis was not supported. The reviewer found no supporting information and analysis in the report or information in the work file supplied by the respondent that would allow the reviewer to recreate the cost approach. The reviewer found that the site value was not properly supported and the cost approach was completed, but supporting information was not consistent with the report or work file. These items can have an effect on the intended user's ability to understand some of the reasoning. However, the reviewer found that the report does appear to contain sufficient information to enable the client to understand and rely on the report. The respondent has been licensed for 5 years and has had no previous disciplinary action against him. Thus, legal counsel recommends closure with a letter of warning regarding the issue noted by the reviewer.
Do I hear a motion to accept?
So moved.
Second?
Second.
Got a motion. Discussion? Hearing none, all in favor say aye. Aye. Opposed, like sign. Please continue.
Item number 5 is 2012-007411. Complaint was filed by a consumer and alleged that the respondent misreported the finished basement on the subject property. The appraisal that is the subject of this complaint was performed in February of 2012 when the complainant had a purchase contract on the house. The complainant alleges that since the appraisal, he has learned that the finished basement does not have heat and air supplied to any of it. However, the appraisal report designates it as finished with a finished basement value included. The respondent states that FHA does not require a vent or any permanent heating source be installed, rather only that it must be adequate for healthful and comfortable living conditions. The respondent states that this is defined as providing and maintaining a temperature of at least 50 degrees Fahrenheit in all living areas and areas containing plumbing systems. The respondent claims that the basement area had an established utility and 3 sides that were below or partially below grade and would be capable of maintaining 50 degrees. The respondent states that reporting the basement as living area is correct and the complaint is not warranted. The reviewer conclusions were that the neighborhood section and the neighborhood market conditions contain very little information about the neighborhood or area. The improvement has indications of non-conforming to FHA supplemental condition requirements. One is the basement area square footage. Typically, the entire basement area square footage is listed, but this report only has the finished area listed. The second issue is the lack of unfinished basement heating. The sales comparison approach had unexplained plus and minus adjustments. The cost approach's land value did not discuss any appraisal method or reconciliation that derived the indicated value. The cost approach was developed on a 23-year-old property with no explanation of the depreciation was determined. The lack of income approach was not explained. There are work file indications that information was added after the assignment was completed. The respondent has been licensed for 12 years with no disciplinary action. However, the reviewer found that the report was lacking in overall completeness and adequacy. Thus, legal counsel recommends the imposition of a $500 civil penalty and a 15-hour residential report writing course to be completed within 180 days of execution. Civil penalty should serve as sufficient economic deterrent while effective education can assist the respondent in becoming a more effective appraiser, thereby protecting the interests of the public.
Do I hear a motion to accept?
I'll make a motion to
Have
accept.
a second?
Second.
Got a motion and a second. Discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Carried.
Item number 6 is 2012005441. This complaint was filed by a fellow practitioner and alleged that respondent overvalued a residential property by using comparable cells 14 miles away from the subject in a superior location. The respondent states that he performed all necessary steps to complete the appraisal in a professional manner. The reviewer conclusions were that the previous transfer of subject property were properly analyzed. Factors affecting marketability and market trends have not been adequately discussed. The sales comparison approach was not completed appropriately. The cost approach analysis was not supported. Reconciliation does not properly address the quantity and quality data analyzed or the applicability and suitability of the approaches used. The work file submitted did not contain all true copies of the appraisal report submitted to the client. The reviewer found that the report lacks sufficient information, reducing the reliability and credibility of the report, which may not enable the client to understand and rely on the report. The respondent has been licensed for almost 12 years. As such, counsel recommends the imposition of a civil penalty in the amount of $500, a 30-hour sales comparison and income approach course, and a 15-hour residential report writing course to be completed within 180 days of execution of the consent order. Civil penalty should serve as a sufficient economic deterrent, while the corrective education should assist the respondent in becoming a more effective appraiser and thereby protecting the interests of the public.
Nicole, does this also fall in, they can claim 21 hours towards continuing education?
Yes, they could get a total of 21 hours for their continuing possible.
Right. Having heard the recommendations, do I hear a motion to accept?
Make a motion.
Have a motion to have a second?
Second.
Have a second. Discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Motion carries. Thank you very much
Thank
for your
you.
legal report. Ms. Avers, Director's report.
Okay. Turn in the iPads to the record report in there and have updated the information relevant to board's activities over the last 30 days. We had a staff hire last month, and unfortunately, Ms. Wade had to resign due to illness, so we are without staff again. The office is working with human resources for temp employees until we can get a permanent employee assigned to the board. Laws for real estate appraisers are in need of revision for the background checks, fingerprinting, federal requirement for 2015. I'm attending the Aero conference this weekend coming up there'll be federal updates from the appraisal subcommittee, from the appraisal foundation, and they have a member from the FBI who is responsible for reviewing the statutory authority the states have for fingerprinting and background checks. So I should have more information for you all next commission meeting on that. Newsletter articles are needed. Mr. Green submitted an article, and he actually solicited an outside reviewer to do an article. Unfortunately, at this point, we couldn't publish yours because we don't have authority over E&O requirements, and was sort of killed by our legal department. The ASC is going to audit Tennessee in January for compliance. They're doing their compliance audit, so we have a 3-day meeting scheduled. I don't know if all 3 days will be necessary for the commission members to attend, but I have booked it for 3 days because of the federal audit coming up, and also because we have an exceptionally lengthy formal hearing coming up in January. So brace yourselves, clear your calendar if possible. Going to make sure that we have quorum well in advance of that meeting, because whatever sitting members will have to be in attendance for the entirety of the formal hearing.
Except for 3 days, did you say?
3 days on the calendar is booked. That's sort of a worst case scenario. I expect it'll take 2, but
What's that date again?
cross your fingers, maybe it'll settle.
What's that date again, Nicole, in January?
I want to say January 14th through the, what's that? It's the 3rd week of January. The revenue and expenditures are posted on the director's report for fiscal years 2010, 2011, and 2011, 2012. And there's a graph showing the balances and budget. And the number of complaints has been updated on the last page, or on the second page, excuse me. We've had 71 complaints so far in 2012 for appraisers. That does not include the prison management company's complaints we've had, so we'll add about a dozen more on top of that for AMC complaints if you want the total for the board. And the final page shows you our license status counts as of October 2nd. That concludes my director's report.
Do you need any action from us at this time about the new licensing laws, about the fingerprinting and that stuff?
If you have legislative contacts that you can reach out to and just kind of keep it on their radar that we need this in the next legislative session, that certainly will be helpful. I'll have more information at the next commission meeting, but right now I don't have any language to share with any professional organizations or legislators at this time.
I'm going over the agenda. Notice that I did not address the application review of Ms. Carol Ann Smith. Is Ms. Smith here today?
I don't believe she has attended, but I think I should present without her. I'll send her a letter. I'm just going to check, make sure she's not sitting out in chairs. Not in attendance today.
What did you do?
My books.
So I assume she's not present, is that correct?
That is correct.
Okay, so we will just, do we need to take any action then at this point in time on that matter?
I think it would be appropriate to go ahead and get a vote on it without her.
Mr. Chairman,
Yes.
I'm not going to participate because I reviewed her work some time back.
You said a motion indicate that should not be approved at this point in time due to lack of a sponsor?
Yes. I wrote up a summary on the application and history on Ms. Smith, and the recommendation staff is that Ms. Easley's application be denied. She has no sponsor for her registration and has failed to submit a course completion certificate for the required 15-hour course of USPAP. Additionally, she's not paid the hearing and investigation costs from the prior formal hearing, and she still has an appeal in Chancery Court for the commission decision, which has yet to reach disposition. I recommend a reconsideration of her registration be denied, and that any future application she submit include a new application fee and all required documentation.
Mr. Chairman,
Yes.
I'd like to make a motion to accept Ms. Avery's recommendation.
Here, a second?
I'll second that.
Have a motion and a second, any discussion? Hearing none, all in favor say aye.
Aye.
Like sign, okay. All right, the next item we have is formal hearing. Mr. Joseph, is this where you step into the picture, sir?
Yes, sir. Yes, sir. We've got the Honorable Judge Kim Summers here to preside with our formal hearing.
Thank you.
We've got our clerk reporter already present.
Thank you.
Thank you, sir.
Let's take anything he's done.
No, don't. I don't want my coffee.
You brought one or two shirts. What's your copy?
I don't think you're going to need the iPads any longer, so if you don't mind, I'm going to just collect those.
I think I have heavy thumbs.
That's okay. Okay, it does take a to get used to it, though. They're kind of.
Oh, yeah, I love it, I just didn't know where things were stored on, you know? I looked first in the bookshelf, and it wasn't in the bookshelf, I didn't think about books.
You mean I can't take this as a gift?
Thank you very much. Thank you.
I got it.
You can take my phone and Operator.
It's like you don't trust us or something, you know?
I don't trust me, because I'm going to forget at some point to collect these.
Easy. Get it up.
Undertakers? I'm going to sit here. Whenever you're ready.
I was wondering if the commission members perhaps need to
If y'all need to take a quick 10-minute break before we get started? Anybody?
All right. Well, good morning, everyone. We are here in Nashville. We actually have two dockets this morning, and I'll start with my general instructions to the board, which will cover both of our proceedings this morning. The first one that we're going to take up will be 12.36-117-120A, and that is in regard to Appraiser loft. And then we also have 12.36-117-121A, and that is the matter of Anthony Mazza, and by agreement with Mr. Joseph, we'll start with Appraiser loft this morning. My name is Kim Summers. I'm the administrative judge assigned to preside in this matter. As the administrative judge, I will not participate in the decision on the merits in this case. The members of the board that are present will make that decision. However, I will make all the rulings on evidence, law, and procedure under the authority granted to me by the Tennessee Administrative Procedures Act. Will each board member please identify him or herself for the record?
Nancy Ford.
Herbert Phillips.
Michael Green.
Norman Hall.
James Wade.
Jason Covington.
Edward Gorilla.
Rosie Johnson.
Mr. Chairman, do we have a quorum this morning?
Yes, we do, Judge.
Okay, Mr. Joseph, will you identify yourself for the
Yes,
record?
my name is Jesse D. Joseph, Assistant General Counsel for the Department, on behalf of the state.
And Mr. Joseph, do we have either respondent here with us this morning?
No, Your Honor, we do not.
Do we want to proceed with information with respect to Appraiser Loft and the proof of service?
Yes, Your Honor, we did file for the record, and we would note that Your Honor's file may also be getting voluminous because we do believe that some of the administrative procedure provisions, first-class mail, has been returned unclaimed as well. We filed a motion to deem service of process complete and sufficient in this case, as well as in the Mazza case. And in our motion, we attached evidence of our certified mail attempts at service of process, all of which came back unclaimed, in addition to the fact that the respondent executed a irrevocable designation of agent for service of process.
Let me just ask you on that point, based upon the mail that I've reviewed, it looked like maybe one of the addresses did not come back, and that would have been the 16745 West Bernardo Drive.
On the first submission of the notice of charges, that's correct, and we did get a signature on that. As a matter of fact, we have exhibits to that effect, but on everything else we sent after that initial one, though even to that address came back unclaimed.
Okay. So there has been no effective service on the respondent with respect to this hearing date?
Other than on the registered agent for service of process,
Okay.
which
Well,
is NRAI.
if you would proceed with your evidence on that issue then.
Yes, Your Honor. We submitted a notice of hearing and charges in June of 2011, and pursuant to the application that this respondent submitted for an appraisal management company registration, they were required to designate a registered agent, which was a company by the name of NRAI, National Registered Agents Incorporated, on Hillsborough Road in Nashville. And the document that they submitted indicated that this company was irrevocably designated as their agent, and they never attempted to change that agent per statute. And we attached a copy of that to our motion, and all efforts to serve that agent were rejected because the agent claimed that the agent could not find an appraiser loan. The certified mail attempt upon Ms. McCarr, as Your Honor stated, at that West Bernardo Drive in June of 2012 was returned claimed, and we did provide a copy of that certified mail return receipt indicating that that was signed for by Vanessa on June 22nd. Ms. McCarr, we obtained a P.O. Box address as a possible additional address in San Diego. That effort returned unclaimed. And we also submitted evidence of a certified mail attempt upon her residential address as per her driver's license. That came back unclaimed.
Mr. Joseph, following receipt of the notice at the West Bernardo Drive address, was there any communication with the respondent at that time?
There was efforts. The phone number that the respondent had provided in the application was unclaimed. Was no longer in service. Phone calls to the registered agent by the way of John Kitch indicated that that office had no further address for the respondent. We've tried the 4 addresses that we've had multiple times.
But there was no effort from the respondent to reach out to you upon receipt of that notice?
Not only that, and the respondent had an obligation per the statute and its application to notify Mrs. Aver's office of any change in business address, if it had any change in business address, and we've absolutely heard nothing from the respondent. So we would ask that on this record, based upon the multiple efforts that the state has made over the course of the past 3 or 4 months, that the respondent be declared in default, and that the state be allowed to proceed as if this matter were uncontested.
Mr. Joseph, can you point to me where in the law they have the obligation to update the department on a change in address?
Okay. Yeah, I can show you that in an exhibit, but I think I've got it attached to our motion. Let me see. If Your Honor looks at this motion that we filed, the state's motion to deem service of notice complete and sufficient on or around August the 3rd, Mrs. Makar states that in her affidavit of controlling person, that she certifies that she's accepted assigned responsibility. If there's any change in my status as controlling person or if my contact information changes, I will notify the Real Estate Appraiser Commission within 30 days of any change.
What page am I looking on?
It should be, I don't know how I think I had this labeled as probably it's the second page after Exhibit 1 of this motion. It's called an affidavit of controlling person. And it's an affidavit of Harpreet Makar. And she states at the bottom that if any of her contact information changes, she will notify the Real Estate Appraiser Commission within 30 days of any change. She would notify the Commission within 30 days of a change in the agent for service of process of record per 623949. That wasn't done. Also, within the statute, within the statutory scheme of this, and under the notice of charges, if Your Honor looks on page 6 of the notice of charges, we have cited 6239-410 designated controlling person, and it indicates that that designated controlling person shall be the main contact for all communication between the Commission and the AMC. We've also cited on page, the same page, 6239-407, which sets forth the completion of an irrevocable uniform consent to service of process. And the state attempted to serve Ms. Makar as well as the uniform agent multiple times. And if the uniform agent or irrevocable designated agent won't accept service of process, and if she won't accept it, we don't know what else we can do.
Well, and the assumption is that they've also not kept in communication with their agent.
I'm certain that we don't have any ability to do anything else.
Okay, well, I mean, it appears to me that the department has made every reasonable effort to notify the respondent about the proceedings today and as previously scheduled in August, so I don't see that we have any recourse but to proceed or to determine that they have received they have effectively received service, or that the department has at least made every reasonable effort to do so. Does the state have a motion?
Yes, Your Honor. We would ask that they be declared in default based upon their failure either to receive service, the failure to communicate with Ms. Avers, and the failure to participate in this proceeding pursuant to TCA 45309, and the state would ask that it be permitted to proceed as if this matter were uncontested.
Okay, Mr. Chairman, having determined that the respondent has, actually the department has made every reasonable effort to effect service on the respondent, it's the duty of the board to determine whether the respondent should be held in default. In making this determination, you will need to consider the statutory definition of a default, which would be if a party fails to attend or participate in a pre-hearing, conference, hearing, or other stage of a contested case the administrative judge or hearing officer hearing the case alone or agency sitting with the administrative judge may hold the party in default and either adjourn the proceedings or conduct them without the participation of that party, having due regard for the interest of justice and the orderly and prompt conduct of the proceedings. If you decide to grant the motion for default, you may either adjourn the proceedings or you may choose to conduct them in the absence of the respondent. I'll leave it for you, Mr. Chairman, and the board to decide how to proceed.
You've heard the opinion rendered by the judge. Do I hear a motion from the commission as to what they would like to proceed, how they would like to proceed?
I move to accept the condition of default and that we go ahead and conduct the hearing.
Second.
The motion, second discussion. Hearing none, all in favor, say aye.
Aye.
Opposed, like sign.
Thank you, Mr. Chairman. We will proceed in this matter then without the presence of the respondent. That being said, just a reminder to the board members that during the time this hearing is being conducted, no discussion concerning this case should take place between board members or with witnesses, attorneys, or other persons unless all parties are present. During the hearing, the board sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires all board discussions and deliberations to be made in public before all parties. Failure to observe the Sunshine Law may result in the board action being reversed or remanded if appealed to Chancery Court. Board members, you are reminded that the law requires you to disclose on the record any outside knowledge of this case or any communication, whether written, verbal, or otherwise, from any parties concerning this case. Does anyone have anything to disclose with respect to this matter?
However, I do have one question before we proceed. Could you just tell me the correct spelling of the name of the company that we're talking about?
I distribute the notice of charges so they can determine if they have any notice of it.
Certainly.
Yes, so then they would know not only
Thank
the spelling, but also the allegations.
Appraiser to buy.
Yeah.
Pardon me, Your Honor.
Oh,
Pardon me,
no. anyone decide differently that there was something to disclose? Very well. During the course of this hearing, there will be an opportunity for each board member to question each witness that testifies under oath. You may use your questions to gain any information which you believe would assist you in reaching a decision in this case. You should wait to share any opinion that you may have until the portion of the hearing which is reserved for deliberations after all proof in this matter has been heard. Mr. Joseph, you have how many witnesses this morning?
We have one live witness, Your Honor, Ms. Akers.
Okay. And for our technical record in this matter, we have a June 13th, 2012 notice of hearing and charges. We have a notice of second attempt at service of the notice of hearing and charges dated June 21st. We have an order from Judge Collier dated July 6, 2012, returned mail from July 11th, more returned mail from July 19th, more returned mail on July 23rd. The state's motion to deem service complete and sufficient dated August 3rd. The state's witness and exhibit list dated August 7th. The state's motion to allow testimony by phone dated August 8th. Order of continuance dated August 23rd. Returned mail from August 29th. Returned mail from September 4th. Notice of intent to introduce affidavit dated September 24th, and a supplemental witness and exhibit list dated October 1st. Mr. Joseph, is there any other thing that would be included in the technical record?
No, Your Honor, that sounds comprehensive to me.
And are there any proof of service items that you want to include as an exhibit in this matter?
Yes, Your Honor, we do. Before we take proof from Mrs. Avers, we'd like to introduce into the record, pursuant to the state's list of witnesses and exhibits, at least 3 efforts of service as exhibits 1 through 3. If Your Honor looks at the state's list of witnesses and exhibits, we'd like to introduce exhibits 1 through 3 as the certified mail, a copy of the certified mail green card that was signed on June 22nd by Vanessa at the address listed by the respondent. Number 2 would be a rejection letter on June 18th we received from the agent for service and process. And number 3 would be a second rejection letter we received dated June 26th from the registered agent for service and process.
Okay, if you would present those items to the court reporter and we have them so marked.
Originals here. A copy for Your Honor, 1 through 3. Each member of the commission. We would ask that exhibits 1 through 3 be entered into the record.
They will be so entered, and we will make the items listed as the technical record, the official technical record in this matter. And as I read through them, reading the state's motion for testimony by phone, are we still having someone testify?
We don't need that, Your Honor. We might have needed that in August because we did serve the respondent with a notice of filing of affidavit about 12 or 13 days ago and received no request to take his testimony, so we would be asking that an affidavit of this witness be entered.
Okay, so we're doing affidavit instead of phone testimony.
Yes,
Very well. I think that is all I have, so if you would like to proceed.
Could I proceed with a brief opening, please?
Please.
Thank you. Members of the commission, my name is Jesse Joseph, Assistant General Counsel for the Department. In this matter, the state's proof will show that the respondent, Appraiser Law LLC, applied for a registration as an appraisal management company with this commission in June of 2011, and that it was issued registration number 57 effective June 1st, 2011 through, July 1st, 2011, active through July 31st, 2013. It will also be shown that the respondent designated a Miss Harpreet McCarr as its controlling person, that the respondent stated its official mailing and physical address to be 16745 West Bernardo Drive, Suite 450 in San Diego, California, within its application, and that the respondent filed an irrevocable consent to service of process, naming National Registered Agents Incorporated at 2300 Hillsborough Road here in Nashville as its agent for service of process. The state's proof will also show within this application that the respondent provided the commission staff, Mrs. Aver's office, with a surety bond in the amount of $20,000 written by the Hartford in June of 2011, as is required by Tennessee Code Annotated 6239-408, and that the administrative staff received notice from the Hartford on October 28, 2011, that that surety bond had been canceled effective November the 28th, 2011. Further, we will prove that the Commission's administrative staff corresponded with the respondent by email and by first-class mail and certified mail in October and in November of 2011, requesting that the respondent restore the surety bond with a new surety bond, which must remain in place during all times in which an appraisal management company maintains an active registration. The proof will show that the respondent did not respond to these communications, and the respondent has failed to provide the staff with evidence of the continuous surety bond as is required by Tennessee Code Annotated. Moreover, within this formal proceeding, the state will show that another certified residential appraiser in this state, a gentleman by the name of Douglas P. Russell, who provided appraisals contracted by the respondent, sent 2 completed appraisal reports to the respondent in March and in July of 2011, for which he was due a total of $575, his cost for these 2 appraisal reports. We will show that Mr. Russell called respondents several times last year, sent an email requesting information as to why these 2 past due invoices had not been paid. His inquiries were not responded to. Mr. Russell then submitted a complaint in December of last year, and he has still not been paid by the respondent through the present. There was never any accusation made by the respondent that Mr. Russell provided substandard services or that he somehow breached his contractual agreement with the respondent as appraisal management company. Proof will also show that before and after the filing of this notice of charges, that counsel for the state has attempted to send certified mail multiple times to the respondent and first-class mail. All this mail has come back unclaimed except one mail that was accepted. Based upon all of the above conduct of the respondent, which the state submits will be proven at least by a preponderance of credible evidence, we believe that the Commission, at the conclusion of this proceeding, we are requesting that the Commission conclude that the administrative staff and the Office of Legal Counsel's efforts to serve the respondent comply with Tennessee Code Annotated 6239, 407, and 410, which are cited for you. Conclude that the respondent's failure to continuously post a surety bond while having an active AMC registration violated 6239, 408A and Section 425.1. And number 3, conclude that the respondent's failure to pay Mr. Russell within 60 days of his completion of the services violated TCA 6239, 421 and 425.1. As to disciplinary sanction, the state notes that the Commission has the authority under Tennessee Code Annotated 6239, 425 to revoke, suspend, or issue civil penalties against an appraisal management company to the maximum allowable in the state if certain violations are proven. The respondent may be penalized up to $1,000 for every violation of the Tennessee Appraisal Management Company Act, and each day of continuing violation may be treated as a separate violation. Since the respondent has failed to submit evidence of a required surety bond for at least 10 months, which would be 300 days, while still having an active appraisal management company license. The commission has the authority, or rather, in addition to that, and since the respondent has failed to pay Mr. Russell these two invoices for between 13 and 17 months, the commission has the authority to impose far more than a $50,000 civil penalty for these egregious violations. However, the state would pray at least for the imposition of a civil penalty of that amount, and that the respondent's appraisal management company in this state be permanently revoked, and that the cost of this cause be assessed against the respondent based upon the pattern of continuous noncompliance with this commission's laws and the utter disregard of the rights of appraisers that the respondent is contracted with, and its utter refusal to communicate at all with the administrative staff of the commission. Thank you.
Thank you, Mr. Joseph. Would you like to proceed with your witness?
Your Honor, the state will call as its first witness Ms. Nicole Evers.
Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Yes. Thank you.
Good morning.
Good morning.
Could you please state your full name for the record, ma'am?
Nicole Marie Avers,
And what is your title?
Executive Director.
And your business address is 500 James Robinson Parkway in Nashville, Tennessee?
Yes.
And how long have you served as Executive Director for the Tennessee Real Estate Appraisal Commission?
Just over 6 years.
Are you a licensed or certified real estate appraiser
Certified residential appraiser.
in the state of Tennessee?
Yes.
As Executive Director, are you responsible for maintaining the official licensing files and complaint files regarding real estate appraisers and appraisal management companies?
Yes.
And to provide the judge with a bit of background, what is an appraisal management company?
Appraisal management company serves as a separation organization, a company separate from the lender and the appraiser. They maintain a panel of real estate appraisers, and they will contract work for on behalf of the lender to get appraisal work done in different states. Many appraisal management companies have review functions so that the entire appraisal process is handled in the appraisal management company before it goes back to the lender.
Are you aware of the respondent in this matter, Appraiser Law LLC?
Yes.
And how are you familiar with this respondent?
They applied for registration as a appraisal management company in 2011.
Okay. And when did the respondent file this application?
In June of 2011.
Okay. Did the respondent complete this application?
Yes.
Was the respondent issued an AMC registration by this board?
Yes.
And when does the respondent's AMC registration expire?
July 31st, 2013.
And when was the date, the effective date of the registration which was issued?
The effective date was when the licensing law took effect, which was July 1st, 2011.
Was a complaint opened by your office in October of 2011 regarding the status of the respondent's surety bond?
Yes.
And can you tell the commission how that complaint came about?
We received a notice of cancellation of the surety bond from the insurance company Hartford, and we requested from the respondent to submit a supplemental or a new surety bond. And when there was no response or new surety bond issued, we opened the complaint.
All right. Have you seen, in this case, Mrs. Avers, a copy of the state's list of witnesses and exhibits?
Yes,
And how did you come to see a copy of that document?
it was provided to me by you.
Okay, I'm going to show you now a set of documents that were listed on the state's list of witnesses and exhibits, listed as proposed exhibits 4 through 10. And I'm going to ask you, ma'am, to take your time, and I'm going to ask you whether or not you can identify the exhibits that I've just handed to you. each of those documents and indicate to the commission what documents you have before you?
Exhibit 4 is the application for registration as an appraisal management company submitted by Appraisal Law, including the affidavit of the controlling person, seal carryover, the ownership and character information for the controlling person, the ID, photo ID of the controlling person, consent for service of process, and the registered agent's consent to appointment. The surety bond is Exhibit 5. Exhibit 6 is the notice of cancellation of the surety bond from Hartford. Exhibit 7 is a Housing Wire article on appraisal law that was discovered by staff. Exhibit 8 is an email from our staff of the board asking for appraisal law to submit a new surety bond or an updated surety bond. Exhibit 9 is the official letter sent requesting the surety bond. Exhibit 10 is the notice of complaint. And certified card indicating receipt for that complaint.
Now, do you maintain true and correct copies, ma'am, of each of the documents which I have just shown you within your official registration file regarding the Respondent Appraiser Law, LLC, and within your official complaint file in this matter?
Yes.
Do you have a business duty to so maintain these documents?
Yes, I do.
And are each of the documents which are listed as proposed exhibits 4 through 10, which you have just testified to, documents which were either received by your office, sent from your office, or obtained from the internet by your staff regarding this respondent?
Yes.
Okay. Your Honor, we would move admission of exhibits 4 through 10 as listed on the state's list of witnesses and exhibits.
Those items, as previously identified, will be entered into evidence as exhibits 4 through 10.
Did I provide enough for all members of the committee? Now, Mrs. Avers, let's begin with exhibit number 4, which is the application for an AMC license that was filed by the respondent, correct?
Yes.
What are the components of this exhibit?
The cover page indicates the address of the appraisal management company along with the controlling person's contact information. The second page is the affidavit of the controlling person. The third page just indicates notary seal and copy. The fourth page is the ownership declaration and character information for, in this case, the controlling person. Harpreet McCarr. The California driver's license for Harpreet McCarr. The next page is the consent to the service of process, which identifies National Registered Agents Incorporated, their contact information, and National Registered Agents Incorporated consent to appointments. This is the final page.
Who within these documents is designated as the respondent's designated controlling person?
Or creep the car.
And what is a designated controlling person under the appraisal management company law?
They're the person that is the primary contact for that company.
What was the respondent's official business address according to this registration application?
16745 West Bernardo Drive, Suite 450, San Diego, California, 92127.
Did Ms. McCarr sign the affidavit of controlling person within this application before a notary?
Yes.
And what does Ms. McCarr state she will do if any of her contact information changes according to this affidavit?
Just above the signature of the controlling person, it indicates that I will notify the commission within 30 days of a change in the agent for service of process record, ownership, or composition, and any address changes.
And what does Mrs. McCarr state in numbered item 4 of this affidavit?
Item 4 reads, maintains an irrevocable uniform consent to service of process pursuant to 6239-407.
And did you find within this exhibit a page captioned irrevocable consent to service of process?
Yes.
Is that document signed by Ms. McCarr?
Yes.
Who is the respondent's irrevocably designated registered agent for service of process?
National Registered Agents Incorporated in Nashville, Tennessee.
And what is that company's address in Nashville?
2300 Hillsborough Road, Suite 305.
Is the provision of an irrevocable consent to service of process required of appraisal management companies in Tennessee?
Yes.
Let's go down to exhibit number 5. What is exhibit number 5?
Exhibit number 5 is a copy of the surety bond submitted by Appraiser Law.
Was this surety bond provided to your office upon the respondent's application for registration?
Yes.
Is that surety bond required by Tennessee law regarding the registration of appraisal management companies?
Yes.
Is Exhibit 6 the notice of cancellation of the respondent's surety bond which your office received from the Hartford?
Yes, it is.
And when did you receive it?
We received it October 27, 2011.
And what did your office do next?
We sent an email and a letter to Appraisal Law requesting replacement of the surety bond, the valid surety bond.
And are these requests found at exhibits number 8 and 9?
Yes, they are.
Did your office receive any response from the respondent as requested in exhibits 8 and 9?
No.
What is the document, let me ask you this. How did you obtain a copy of the internet article from Housing Wire regarding the respondent, which is found at exhibit number 7?
I received several newsletters from a variety of appraisal sources, and I believe that one was forwarded to me, and I went to the internet and printed out the article since it was relevant to an appraisal management company registered in Tennessee.
Now, after your office, Mrs. Avers, sent out the November 4th, 2011 letter to the respondent, which is exhibit number 9, what did you do next?
We gave them time to submit the insurance, and when they did not, then a complaint was opened, as indicated in Exhibit 10.
And exhibit 10 is a certified mail notice of complaint letter dated November 18th, 2011.
Yes.
And a copy of the signed green card establishing that respondent received it on November 28th, 2011.
Yes.
Did your office receive any response to this complaint from the respondent after November of 2011 through the present?
No.
Has your office received, ma'am, any replacement surety bond from the respondent after the Hartford bond was terminated in October of 2011?
No.
Your Honor, we want to keep Mrs. Avis on the stand because we have a second complaint in this matter. But at this juncture, pursuant to the state's list of witnesses and exhibits, and given the fact that Your Honor's record reflects that we did serve the respondent with a copy of Mr. Russell's affidavit.
Mr. Joseph, before we proceed with the affidavit,
Okay.
do any
I'm
of
sorry.
the commission members have any questions for this witness? Okay.
I'm sorry, I forgot about that. That was the termination of one complaint. But in the second complaint, Your Honor, we have served a notice of filing of affidavit on the respondent, and we had listed the 4 exhibits that Mr. Russell had attested to as being authentic as exhibits 11 through 14, which are an invoice that he submitted to the respondent in March of 2011 for $275, an invoice that he submitted to the respondent, number 12, in July of 2011 for a $300 appraisal, an email that he sent to the respondent on December the 13th, 2011, inquiring about the status of these 2 unpaid invoices, and Exhibit 14 is a complaint submitted by Mr. Russell against the respondent based on the respondent's failure to pay these 4 invoices, these 2 invoices. And given the fact that these were attested to in his affidavit and authenticated by Mr. Russell, we would ask that those 4 documents be entered into evidence for purposes of continuing the numeration that we've already provided as exhibits numbers.
Well,
11
Mr.
through
Joseph, do
14.
we want to make that, because it looks to me like in this document you provided that you have exhibits to the affidavit, so do you want to make the affidavit an exhibit and then have exhibits to the affidavit, or do you want them to all be separately
I've all got them
designated?
separately numbered. I
Okay.
don't mind. We filed a supplemental list of witnesses and exhibits, and I understand the question. We had numbered Mr. Russell's affidavit as number 17, and we have 2 other documents that Mrs. Avis was going to testify, which was 15 and 16. So we'd already pre-marked the other exhibits as exhibits 11 through 14. So for purposes of continuing that numbering and not having to remark, it might be a little easier to put them in as separate exhibits.
Okay, so you're going to have what is now included, what you filed, there's what, 4 exhibits
Yes.
included with the affidavit, so
Yes.
you're going to number those as separate exhibits and then have the affidavit as
Yes, Your Honor, we've
exhibit.
already got that done.
Okay,
As a matter of fact, we have them here, exhibits 11 through 14. Mrs. Avers,
are we entering the
yeah, are we entering what?
the affidavit? Or
Can
you're
we-
waiting on that?
Can we go on and enter it at 17
Okay.
now? I can enter it at 17.
Okay.
And take them out of order. We can do 15
Well,
and
that's
16.
fine, I was
That's
just a
fine.
little confused about how you were
I was trying to
proceeding.
keep my numbering consistent with the prior list of witnesses we had already done. But if Your Honor will allow me, I'd like to introduce the affidavit as Exhibit 17 and then go back to 15 and 16. Is that
Okay,
fine?
that's good.
And at least you can have that in front of you.
We would like to have about a 10-minute break if we may, sir.
That'll be fine.
Okay, we stand in recess until 10 a.m., please.
Thank you.
Your Honor.
Mr. Joseph?
Thank you, Your Honor. Mrs. Avers, you've seen exhibits 11 through 14 that I've just presented you, have you not?
Yes, sir.
And what is exhibit number 14?
Exhibit 14 is the complaint submitted by Douglas P. Russell against appraisal law indicating unpaid invoices.
This is the second complaint that's involved in this notice of hearing and charges, is it not?
Yes.
Now, with respect to this second complaint against the respondent appraiser law, did you send this out to the respondent and to the agent for service and process?
Yes, I did.
And what did you receive back?
There was a rejection notice from the agent for service and process, but no response to the allegation.
I show you now exhibits, proposed exhibits 15 and 16, and I ask you whether or not you can identify these documents.
Exhibit 15 is a letter indicating that the complaint has been opened and request for response that was sent to appraisal law on December 15th, 2011. The second page of Exhibit 15 is the return of unclaimed certified mail copy of the envelope. And item 16, Exhibit 16, is the letter sent from National Registered Agents indicating that they marked NRAI can find no record of the entities listed with the state authority.
Okay. Now, are each of these documents either received by your office or generated by your office?
Yes.
And are all of them included within your official complaint file in this matter?
Yes.
Do you have a business duty to so maintain them within your official complaint files regarding this respondent?
Yes.
Your Honor, we remove admission into evidence of exhibits 15 and 16, the December 15th, 11 certified mail notice of complaint letter to respondent, and the November 19th rejection letter from NRAI refusing acceptance of the notice of complaint letter.
Okay, and just in case I was not clear, we have exhibits 11 through 17, and we will enter all of those into evidence as previously indicated.
Oh, thank you. Now, Mrs. Avers, did you ever receive any response whatsoever to this complaint, exhibit number 15?
Not from appraisal law, no.
Have you ever been told by Mr. Russell that he has ever received payment from the respondent on these invoices?
No.
Have you heard anything whatsoever from appraiser law through the filing of this notice of hearing and charges?
No.
Have you heard anything further from appraisal law regarding any of these complaints to the present?
No.
No further questions, Your Honor.
Any questions from the commission members?
No, Your Honor.
Okay, anything further, Mr. Joseph?
Your Honor, that will conclude the state's proof in this matter.
Okay, would you like to make your closing statement?
Briefly, members of the commission, the state submits that this case is simple. Appraisal Law LLC applied for an appraisal management company registration under the new appraisal management company laws of Tennessee in June of 2011. It was granted a Appraisal Management Company registration in July of 2011. There were a number of specific statutory requirements it had to adhere to, specifically the requirement to maintain a surety bond in an amount of at least $20,000 during all periods in which it had an active registration. It did not do so. It did not respond to the administrative director's notifications, emails, or notices of complaint regarding that matter. Appraiser Loft also designated an individual by the name of Harpreet Makar as its designated controlling person. That person, pursuant to Tennessee Code annotated provisions, which we've already cited, was in responsible charge of the operations of the company, had an obligation to notify Mrs. Abrams' office if there was any change in business address of the company. The company also had an obligation pursuant to Tennessee Code annotated provisions to designate an irrevocable agent for service of process. It did that. That agent of service of process either outright rejected the service or indicated that it had no new address on the respondent. The state submits that it did everything it was supposed to do, but that the respondent has not adhered to its responsibilities under the statutory scheme. The respondent's license technically is still in effect until July of 2013, and the state submits that based on this record and the utter failure of the respondent to respond, to provide a replacement surety bond, and to meet the obligations of appraisers that it is contracted with, such as Mr. Russell, is conduct which should be punished. The state submits that the respondent, based on its disregard of Tennessee law, its failure to communicate, and its failure to comply, should be permanently revoked, and that a civil penalty based upon the numerous days of violation, more than 300, for which the commission could impose a civil penalty of $1,000 per day for each day of continuing violation, that a civil penalty in at least a minimum amount of $50,000 is warranted in this particular matter, and that the cost of this cause, including the cost of the court reporter and the administrative procedures division, should be assessed against the respondent, and that is the state's request in this case. Thank you.
Thank you, Mr. Joseph. This matter will now be submitted for consideration and decision by the commission. This matter must be decided only from the evidence which was presented at this hearing. That consists of, the evidence in this matter consists of sworn testimony from our witness and also one affidavit that was marked into evidence. Statements of counsel made during the course of the proceedings are not to be considered as evidence. They are only argument presented for in order to convince you of the merits of their particular position. In this matter, you are required to issue an order that contains findings of fact, conclusions of law, and the policy reason for your decision. In making your decision, you must consider the evidence in light of your own reason, training, experience, expertise, and common sense. You must make findings of fact based solely upon the competent evidence that was presented before you in this hearing. Mr. Joseph, do you have proposed findings of fact or a proposed order to present for consideration to the commission members?
Your Honor, we would ask that the commission utilize the notice of hearing and charges as the state's alleged guidepost for consideration in lieu of a proposed set of findings of fact.
Okay. If the commission members would use the notice of charges as their guide in crafting an order, and this notice of charges is to be used only as a guide, it's still the obligation of the commission members to actually come up with their own findings of fact and conclusions of law, and the more specific that you are in doing so will make the order have a better legal basis should it be appealed. The state has alleged that the respondent has violated certain state statutes and rules. The state has the burden of proof in this matter. It is the state's burden to prove its allegations by a preponderance of the evidence, which means that the greater weight of the evidence is in favor of the state. You must limit your inquiry regarding the violations of statutes and rules to those violations alleged in the state's notice of charges. Once you have made your findings of fact and decide whether or not the respondent has committed the acts or omissions alleged by the state, you must decide if the respondent's alleged acts or omissions constitute a violation of the state statutes or rules. You must then state your conclusions of law. If you decide that there has been a violation, you must decide what disciplinary action, if any, is appropriate in accordance with your legal authority and the particular aspects of the case. For this purpose, you may consider any evidence that the parties have introduced, for instance, whether the alleged conduct was or is continuing or only a one-time offense. You may revoke, suspend, place on probation, reprimand, assess a penalty, or otherwise discipline a licensee. These are only examples of possibilities, but not any recommendation to the board on what it should do. If you find that the state has carried its burden of proof and have articulated your findings of fact and conclusions of law, you must state a policy reason for your findings and conclusions, which explains why your decision in this matter is appropriate. All motions must be carried by a simple majority of the board. Unless there are questions, I will now turn the hearing over to the chairperson to preside over the deliberations.
Thank you, Your Honor. Members of the commission, we had the allegations of law, recommendations as for the disposition of this matter. Here's a motion or comments from the commission.
Mr. Chairman, I would move that we accept the allegations of fact as written in these statements of fact.
Do I hear a second? Got a second. Do I hear discussion? Hearing none, all in favor say aye. Aye. Opposed, like sign. Motion carries. The next item we need to consider.
If I may, Mr. Chairperson, if you would specifically go through the charges on the specific findings of facts.
Yes, ma'am. Your Honor. The first allegation that we conclude is correct was the Tennessee Code 62-39-408 restoration fees surety bond. Bond has been canceled, so that's a violation. The next one, 62-39-421. Payment deadlines to appraisers. It's found that the respondent, Appraiser Law LLC, has not made payments to appraisers. Number 3, the 62-39-425 grounds for censure, suspension, or revocation of restoration. Is this?
I think we're on the wrong section.
I think Commissioner, Mr. Chairman, is going into the conclusions of law section and may not have understood your Honor's instructions.
Okay.
I'm sorry.
It's just with respect to crafting an order,
Yes.
a specific recitation of the facts is helpful should the order be appealed. So if we could just specifically go through the facts and just specify, even by number, what facts are specifically being adopted for purposes of creating the order. And the facts start on page 2 of the notice of charges.
Okay. Just to make sure that I'm properly responding. Could it be proper to say that we've agreed the allegation of facts as the bond has been revoked? Would that be proper?
Well, I mean, the more specific you can be, the better. But I mean, I think even if you said, the allegation of fact with respect to, paragraph number 1, and then maybe the facts as alleged with respect to this case number, paragraphs 2 through 6 are adopted. Just that is just a suggestion so that
Thank you.
we can be clear about what facts are being agreed upon. There's no, I mean, we don't obviously have any reason to believe that this matter will be appealed, but should it be appealed, the court will look at this and want to make sure what you actually considered in finding a violation should you choose to do so.
This be reference to case number L11-APP-RBS-2011030081. Received a notice of cancellation bond, and the company was required by law to keep a bond in force. It was proven that they did not have a bond. We adopt items 2 through 6 of the allegation, and then on case number L11-APP-RBS-2011032181. This is in regards to a claim by Douglas P. Russell about non-payment. Proof went on to show that Mr. Russell had not been paid by this company, which puts the appraisal law in violation of that.
And if you would take another vote based upon those facts, that would be fantastic. Thank you, Chairman.
All those in favor, please say aye.
Aye.
Opposed, like sign. Now, we're now down to the disposition of the case.
The conclusions of law,
Conclusion.
yes.
All right, conclusions of law, that was where
Mr.
I
Joseph,
was.
did you?
I didn't hear anything under the allegations of fact as to the decision on proposed number paragraph 1. I thought I heard some discussion at the start.
I think that may be true, actually, about the position of their, or the status of their license.
Okay. The above motion made to also include item 1, which was you said vote on that also?
Please.
Okay. All those in favor say aye. Aye. Opposed, like sign. Are we now over to the alleged conclusions of law? Are we at the,
Yes, we are. Thank you.
is this where I should have, this is where I should be now, right? Is, okay, alleged conclusions of law, and this is restoration fees, assured to bond, which not been paid or has been revoked. The payment to appraisers, all of these lead to grounds for censure, suspension, or revocation of restoration.
And all you have to do here, Mr. Chairman, is link the facts that you have already found to these particular statutory provisions.
And I believe we would have found that the company is in violation of the various statutes and provisions as shown. Correct? Okay. Now, for this commission's findings on this position of this matter, which has been recommended that fine of $50,000 be revoked plus cost of the hearing.
Mr. Chairman, before we get to the actual penalties, if we could discuss, we actually have to have a finding that, for instance, based upon 6239-408, the specific facts that you have found that would support a violation of that particular statutory provision. And then once, if you have found a violation, then you all can go on to discuss
Do you want to go over these individually?
That would be helpful, yes, to
Okay.
say that which facts that you found support a particular statutory violation.
The first item we have is the registration fees surety bond. Does the commission have a opinion on that particular item? According to the information presented by counsel, the company Appraiser Law did not maintain that surety bond. In fact, it has been revoked, and therefore they have not reapplied. And therefore, that puts them in violation of 62-39-408. Does the commission agree to that?
Yes.
All right. Payment deadline to appraisers, which is 62-39-421. It was alleged that they had failed to make payment to appraisers. We have affidavits to show that they had not paid the appraisers for their services, and so therefore they are in default on those grounds.
We have evidence for that.
Yes. We have affidavits from the appraiser. Also, 62-39-425, grounds for censure, suspension, preliminary censure, an appraisal management company, conditionally or unconditionally suspend or revoke any registration issued under this part, or impose an administrative fine not to exceed maximum allowable amounts defined by the state of Tennessee. And it is found that they have continuously for over 300 days violated the part of the Tennessee Code that required them to have a bond and also be able to find where they are located. They did not keep up, let us know where they were at all times. And I think the commission will agree that they are, it's been proven that they are in violation of this. The next item would be 62-39-407, completion of revocable uniform consent. This particular item, they have failed to maintain with the state of Tennessee where they may be reached, and management company evidently designated place of business here in Nashville is no longer there. Does not designate controlling person. Controlling person will be the main contact with all communications. Once again, this has been violated. Does not maintain that within the coverts of the law. And,
If you would vote, take a vote on those first 4 provisions, and then we can move on to 5, which I believe deals with the penalties.
okay, all those in favor say aye.
Aye.
Opposed, like sign. Okay, the next item is number 5. And this is the item that deals with the Tennessee Code annotated 62-39-408, parentheses B, parentheses, 62-39-421, and 62-39-425. Violations constitute grounds for revocation, suspension, or censure of respondent's registration of the appraisal management company, and for the imposition of other lawful discipline, including the imposition of civil penalties.
You all have to deliberate on the appropriate penalties.
That at this time, then we'll deliberate as to what the penalty will be for this company. Once again, it's been one of the recommendations are irrevocable, permanently revoke the license for this company, civil penalty of $50,000 plus the cost of these proceedings. Does the commission have any feelings on this?
I have a comment, Mr. Chairman.
Yes, sir.
I think that $50,000 is low. I think the maximum penny of $1,000 a day should be applied, so maybe $300,000 based on 300 days. I think that the license should be revoked, as you said. I think that they should be given the cost of this hearing and also the cost of the court report.
We have that as a motion. Do I hear a second for discussion?
Second.
Okay, a second, discussion?
The only thing that that may be lacking, what about the appraisal fee? As opposed to the appraisal, is that handled within that fine, or is that something that has to be dealt with separately?
Do we have the jurisdiction to say that they have to pay that? I don't believe we do. Maybe we do.
If you all would like to suspend your deliberations to hear from Mr. Joseph, we can do that.
I would like to make it.
Okay. We're going to suspend the hearing at this point in time to hear from the legal counsel, Mr. Joseph.
My understanding, members and Your Honor, is that the requirement for appraisal management companies to maintain a bond is such that claims that might be made by appraisers that are doing work for them, and if they don't pay them, could be paid by the bond. Our understanding on this record is that there is no present bond available because it was revoked. So there doesn't seem to be any mechanism by which the state would have the money to pay that claim. And this may go beyond the contested case proceeding, but this is just my opinion. It may very well be that our department may have to implement some mechanism to process claims. And we don't have that in place if there was an existing bond. So I feel that if there was a bond available, they could be paid from the bond. But insofar as a disciplinary sanction, we're talking about what can be taken against the license, and I think we're talking about civil penalties, revocation, suspension, etc., and costs. But I'm having a little difficulty seeing how we can put in an order that they're required to pay this money to Mr. Russell. I think they should have to pay it, but I just don't know administratively if we have that authority.
So, Mr. Joseph, you're indicating that generally speaking, claims by third parties would be handled outside of this type of proceeding.
I think it would have to be on the record as it exists now, unless there was some additional regulation or scheme set up.
All right, thank you, Mr. Joseph. Any additional questions for?
But let me,
You finish.
so basically, the appraiser would probably have to go on the small claims court or something to try to put that fee back. He couldn't come through this system here.
I'm just having...
Not that I'm trying to get wrong.
My legal opinion is that I just think that if there's no current bond in place, because if this company still had a bond on file, I think it might be doable. But if there is no surety bond in place because it got revoked, and we had evidence of the revocation, there's no fund for us to pay that kind of claim.
That's sort of, what's my question, I guess? It says the bond was revoked November the 28th of 2011. The appraiser's invoices are dated March of 2011. So I don't understand the bonding process well enough to know, because there was a bond in place at that time, could it be enforceable, even though it's been revoked after the invoice?
I'm not sure. In as much as, since we know that there is no fund of money to pay the claim, because the bond has been revoked at least for the past 11 months, I don't know any way we would say that there is any money from the Hartford to do that. Now, let me say this. I don't think it's necessarily outside your statutory authority. John may want to opine on it. I'm not sacrosanct on this, but you may very well be able to order that the respondent notwithstanding the civil penalty, be ordered to pay this money. Well, if that doesn't make sense. If there's a permanent revocation, it depends on what you order. There would be no further license. But I was thinking that if the respondent ever were to be allowed to seek a registration again, that in addition to anything else you impose, you could possibly put in the order that he be required to provide evidence that he's paid this particular appraiser, if there was going to be a reapplication.
Would it be appropriate for us, the commission, to ask the state to ask Hartford about the bond and paying the appraiser retrospective?
I don't know how we can enforce that in a final order against the respondent. We in essence would be asking for some legal opinion, or they're not a party to this proceeding, and I just don't know how we can do that. I think that outside the confines of this case, maybe there needs to be some consideration given to what kind of administrative system the state wants to set up in order to be able to enforce payment of these bonds or claims on these bonds. I don't think that's been looked at yet.
If this is a matter of concern with the commission, you can make a motion to reopen the record to hear further testimony from the executive director if that's something the commission would like to do.
Mr. Chairman, may I make an amendment to my motion?
Yes.
I'll make an amendment that the commission has found that.
Well, we're not currently in
Shall we go back in
deliberations.
session?
Yes.
Back in session. Okay, shall we go back in session? All right, back in session, go.
I would like to make an amendment to my motion to say that the commission has found that, based on the evidence, the appraiser is entitled to payment of his appraisal fees, and that if the security bond was in effect at the time that he did his appraisals, he's entitled to that money. But we have no authority as a commission to, the state does not have a position where we can, at this point in time, pay him for those. So, but it is our finding that he is entitled to those fees.
I'm not sure. Would that be appropriate or not?
I mean, just as a suggestion, making it a requirement that those fees be paid should the company with those principles ever reapply in the state of Tennessee.
That's the intent of your motions, isn't that
That is my intent, and, in other words, in addition to that, having said what I did say, if they ever reapply, the appraiser's fees would have to be paid in addition to the other monetary penalties that have been applied.
You have made a finding that there are unpaid invoices, so you could include in your remedy that those invoices should be paid prior to granting appraisal loft with those principles, any other license at any time in the future.
I would like to include that comment in my
So, Councilman, if I...
helpfully said.
All right. So, Councilman, if I understand the motion that's on the floor right now is, number one, that we revoke the license, permanently revoke the license of appraisal law or any of its principles to do business here in the state of Tennessee. And that the fine, based on what you recommend, Jack, would be $300,000?
Correct.
Be $300,000. And that the company be liable for all costs of this proceedings, which will include the judge, court reporter, etc., witnesses. And three, that the appraisal fee would have to be paid before this company and any of its principals would be allowed to do business here in Tennessee. Is that correct?
That is my motion.
Do we have a second? We got a second. All right. Any discussion on this motion? Okay, Jason?
Couple of questions I have. We've got one official complaint on one appraiser. If any other appraisers file a complaint going forward and this AMC wants to register again, I think any formal complaint concerning an appraiser fee needs to be included as well, if that makes sense. Based on my exhibit, I believe number 7, I have some questions about exhibit number 7 that leads me to some things I don't understand, I guess. Exhibit number 7 is the news wire, housing wire, stating this company's gone out of business and owes over $3 million in unpaid appraisal invoices. We know $575 of that $3 million. So I guess kind of my question is, just in general, no matter what penalties and or fines the commission deems appropriate, are these people in business? Just a general question. And if so, how are we going to enforce our, maybe this is a question for the state, I don't know. But no matter what we come up with, are these people still in business? And secondly, most importantly, any other appraisal fees not paid by this company that are formally complained upon, I think should be tagged on to what we're doing here with this $575 based on this particular appraiser complaint by Douglas Russell.
May I respond? Mr. Chairman?
Yes.
I don't feel like we have added evidence to the additional complaints today, and I don't think in this hearing we can address that. And as far as whether in business or not in business is kind of a moot point with the proceeding today, because we're dealing with their license, with the penalties that involve the state of Tennessee, and so I feel like that my motion should cover all the points that we've addressed today in the evidence and testimony.
And I will add to that and say that your order can only address facts that were presented in this proceeding, but it would not have any impact on any future proceedings. Should there be complaints made against this company in the future, that would be handled as a separate complaint.
Any other discussion? Hearing none, all in favor of the motion say aye.
Aye.
Opposed, like sign.
Policy statement.
Okay, the Tennessee Real Estate Appraisal Commission is charged with the duty to regulate the practice of real estate appraising and appraisal management companies in the state of Tennessee, such that the citizens of this state receive all such services in accordance with state law and regulations. Because the respondent has violated the law and regulations governing the practice of appraisal management companies in the state of Tennessee, it is in the public interest of the citizens of this state and for the protection of their welfare that we have revoked the license of Appraisal Law LLC to provide services in this state.
Very good. And if you all will take a vote on the policy statement.
Mr. Jess?
Oh,
Your Honor, I just have, before they conclude, I just want
well,
to
they
make
have
sure.
to take a vote on the policy
That's fine,
statement.
I have one other
Okay.
question.
Okay, all those in favor of the policy statement, signify by saying aye.
Aye.
Okay, opposed, like sign. Mr. Joseph?
Your Honor, since I'm going to have to draft this, I want to make sure I don't put anything in here that can be looked at as internally inconsistent. Now, in my prayer for relief, the state requested a permanent revocation of this company's registration.
Yes, sir.
All right. My understanding of the motion that was just made, including that the revocation and the $300,000 civil penalty and cost, and that these appraisal invoices of Mr. Russell have to be paid, et cetera, was that the commission both ordered the permanent revocation as well as a requirement that if they ever apply for recertification in the future, that these amounts have to be paid. It's
Sounds like,
inconsistent
yes.
for us to say permanent revocation and allowing a future application. So I want to make sure I understood what was the disciplinary penalty that was ordered, so I can write it up correctly. Was it permanent revocation, or was it simply revocation, and they would have to pay these penalties and costs before they could reapply?
Commissioners? Permanent. Permanent revocation.
So, based upon that, it seems
Yes.
like one of the
Right.
penalties would not be,
Yes, that'd be the one if they ever reapply, because if reapply, they're going to be denied anyway because we permanently revoked it. Is that correct?
So the issue about the appraiser being paid,
Permanent revocation seems to imply that you can't reapply for re-registration as this into this type of AMC.
Right.
There could be no reapplication in the future, correct?
Yes, sir. So the only thing, if that's the case, then do we need to amend the motion to eliminate the part if they ever reapply? Because if we have said it's permanently revoked, then they cannot reapply. Is that
Well,
correct?
you can revoke for some period of time, and after that period of time, if they reapply, they have to pay these costs and penalties in full and appraisal fees.
Mr. Chairman,
But they would still have to pay the $300,000 regardless, correct? Is that correct?
That's right.
Okay. All right. Yes, sir.
it was my intent of my motion that, as I said originally, I did not think that we had the ability to make them pay the appraiser's fees. But my intent was to, for the record, to show that we, as a commission, felt like the appraiser was entitled to those fees. And if there's any payment that could be made by the surety bond, that they should pay the appraiser those fees.
Is that a separate issue? Or would that be part of this? But once again, we're back to the thing, if we permanently revoke the ability to operate here in Tennessee, then there's no money in land, there'll be none in the future.
Well, may I address that?
Yes, sir.
My point being that, all I'm saying is that we heard in the evidence that the appraiser did provide the service, that the appraiser was not at fault in any way in a substandard appraisal, and that he should be entitled for any future court proceedings that he could use this record to show that we did consider that, and that he would be entitled to those. As I said originally, we don't have the authority to really, I felt like we didn't have authority to make that, but, there's other discussion at the time.
Well, the problem is, I believe that, once again, we've got 3 attorneys in this room that can correct me very quickly here, but once it is permanently revoked, that ability to practice here in the state of Tennessee, then there is going to be nothing for the appraiser. Now, I am an appraiser, and I want to get paid like everybody else, but there comes a point in time where you have to say, we've done everything we can. And I think when we permanently revoke his license, I feel for the guy, but by the same token, I just do not feel that we could put that as part of the order at this point in time.
and if I may, you have made a finding that appraisal work was done and not paid for, and that there was at least some point in time a security or surety bond in effect. So you have that in your findings of fact. That may be as far as you can go with that particular issue within the context of this proceeding.
Does that answer your question?
Well,
I think we may need to just clarify your remedy with respect to that one particular provision insofar as your statement that the revocation will be permanent.
So, pardon me.
Go ahead. I have a question.
If you got a question, go ahead.
I don't want to convolute this any further, but we are talking about individuals and a business, appraisal law, and Park Pete McCarr, and also, I would only assume her husband, a man, Amen McCarr. As far as discussion is concerned, I would believe that as individuals, we should include them if they apply under any other name as an appraisal management company.
I was under the impression that was already, we'd already said that this company or anyone affiliated with it at this point in time.
I think you did say that you said principals as well as the company.
Exactly. You know, that would include everybody, you know, on this thing.
I heard that, yes.
Okay, well, that was my thinking. So the only thing we really need to clarify at this point in time is the fact that, number one, we got a permanent revocation of their ability, the company or any of its principals, or anyone associated with it, to practice here in the state of Tennessee. Number two, we got a $300,000 fine. At this point in time, I think that's where we're going to stop. Is that correct? Yeah, including court costs and the court costs. Would that cover it?
And that they not be permitted, any of the principals of the company be permitted to reapply until said $300 fine
Has been paid.
and costs are paid in full.
Okay.
Well, does that again not undermine the permanent?
Well, I didn't understand his last motion included from.
Do you? That's I think what the board or what the commission
Yeah.
needs to determine is it permanent under any circumstance, or is there a set of circumstances under which you would want these either the company or these principals to again have another license in the state of Tennessee?
Okay, you just asked the commission that question. Do y'all want them, if they paid $300,000 in court costs and anything like that, to be able to reopen an office here in Tennessee? Or you just want to say no, we're not going to let you come back in here, but you still owe us the $300,000 plus court costs?
I think it's permanent and they still owe us the $300,000.
Plus
Because
the
that's
court costs.
it's not
Yeah.
the future, that's
Right.
what they didn't pass, the $300,000 penalties from the past.
Okay, would that solve the problem we have here?
It's permanent
Right.
without condition, is what you're saying.
That's right. Okay, I can understand that.
Okay.
And if just clarify another voice vote on that,
Okay.
on the permanency without condition.
Okay, so the motion is that they will be permanently revoked. They'll be fined $300,000 plus the court cost and any other costs related to this hearing. And that none of the principals or anyone related to this company will be able to ever make application here in the state of Tennessee. Does that meet all the criteria? Okay, everybody has heard the motion, do I hear a second?
I'll say.
Got a second to it? Discussion, any further discussion? All in favor say aye. Aye. Opposed, like sign. Okay?
Anything further, Mr. Chairman?
No, Your Honor?
Mr. Joseph?
Thank you, Your Honor. That should conclude the matter. Thank you.
Okay, well, we will adjourn this matter. Are we ready to take up our second?
What is it?
Oh,
Yeah.
Right, yes, Your Honor.
Everybody can have one except as a recreation.
Joseph, are you ready?
Well,
No.
Your Honor, if you like, if I may address the commission beforehand. Just so the commission members know, the applicant, Carol Easley Smith, did show up during the first formal hearing, and she was sitting in the back of the room. On break, I advised her that the commission had already voted on her matter, that she was late for her appointment, and that if she wished to, she could wait until the commission was done with the first formal hearing and then address them if the chair reopened the matter. She seems to have left again. So if it's okay with the chair, I'm just going to send out the original
intended letter to the applicant indicating her application was denied and instructions for any future application. I just want to make sure I called it to the record.
Okay. So I reckon we need to call this commission back in session, do we not?
Yes.
Okay. So say Appraiser Commission is now back in session. Mr. Joseph, are you ready, sir?
You're ready?
Yes.
Okay. Well, as previously indicated, we do have another contested case scheduled on this docket, and that was the matter of Anthony Mazza, and that is 12.36-117-121A. And as previously discussed, we have identified our commission members and that we have a quorum also for this contested case. And what we need to take up now, Mr. Joseph, is whether or not we have Mr. Mazza available for this hearing.
Well, Your Honor, no, we don't have him. Just as was the case previously, we attempted to serve him, but we have not been successful, and we did file in this case, just as we did in the other one, a motion to deem service of process complete and sufficient. And if Your Honor wants me to go into that,
Please.
I can. Well, we filed a notice of hearing and charges in this case, Your Honor, just as we did in the other one in June of this year. And in this particular case, this respondent is not licensed or certified as an appraiser in Tennessee. So we're dealing here with allegations of unlicensed conduct. We have never received any application whatsoever from him. And our case is based upon his allegedly performing 2 appraisal reports in the city of Kingsport, Tennessee. On the mailing address for the cover page of the 2 appraisal reports, we were provided with a company by the name of Eastern Realty Corporation at P.O. Box 422 in Scioto, Pennsylvania. At the time these reports were prepared, he was affiliated with that company. We attempted certified mail at that P.O. Box for Eastern Realty, and at that P.O. Box it was returned unclaimed in July or late June of 2012. We also obtained a address for a registered agent for the corporation that we believed him to be working at, which was Eastern Realty Corporation. We obtained an address for a registered agent in the state of Delaware, and we did serve the registered agent in the state of Delaware on June the 14th, 2012. And we've got a signed green card from the registered agent for the corporation, Eastern Realty Corporation in Delaware. Now, what else have we done? Mrs. Avers has executed an affidavit indicating that she searched for this respondent on the internet. The respondent never provided us with a middle initial, and the only name we have is Anthony Mazza. According to my research and according to Mrs. Avers' research on the internet, there were more than 200 people with this same first and last name, according to Google, and there was no middle initial provided. We also did further research on the search engine or website for LinkedIn for professionals. We found no Anthony Mazza that met this description of providing these types of appraisal reports out of Scioto, Pennsylvania. The phone number that was listed on both of these appraisal reports, which was 570-236-8827, was not in service. We searched both the white pages and the yellow pages for Scioto, Pennsylvania, and found no listing at all for Anthony Mazza. And given the fact that he never had a license and never had a certificate, we don't know how to locate this individual other than to do what we've done. And there's no way we can identify which of any of the nearly 200 individuals found on the internet was this respondent. And given that he doesn't have a license or certificate, he doesn't have the same degree of due process protection as does a licensee. But the state has done, notwithstanding that, we think we've done all we can do and what is reasonable. We believe that under these circumstances that the certified mail attempts at service that we've made should be deemed sufficient, and that the respondent should be deemed to be in default, that the state should be permitted to proceed today as if this matter were uncontested. And by the way, we have attached to our motion to deem service of process sufficient, we've attached Mrs. Avers's affidavit as Exhibit A. We've attached complaint material, and we've attached other information, the certified mail return receipt that was signed by the registered agent for the company, and a copy of the certified mail notice that was sent to the respondent that was returned to us unclaimed. We just don't know what else we can do to locate this respondent.
Well, based upon the efforts that the state has gone through to contact this individual, sending a notice to every address of record, and all of the efforts that Ms. Avers has gone through to identify this individual, I consider that the department has made every reasonable effort to notify the respondent of these proceedings. Do we want to make the exhibits available to the board members for purposes of, well, does the state have a motion?
Well, yes, Your Honor, we would request that this respondent be declared in default, and that the state proceed as if this matter were uncontested. That is our motion.
Do we want to provide the proof of service documents to the commission members before they consider your motion?
Well, if I had additional copies of my motion, I certainly would do that. I'm trying to locate right now a separate list of witnesses and exhibits, and I want to see just exactly what I listed as exhibits.
I think that you had, you did have a certified mail green card, the affidavit. Looks like exhibit number 1, 5, 6, and 7 all pertain to proof of service.
1, 5, 6, and 7. I can certainly, I have those ready, quite frankly. Exhibit 1 is a copy of the certified mail notice of receipt that went to the registered agent. This is Your Honor's copy, and that's also an attached copy of the USPS.com demonstrating that it was received on June 14th. I've also got 5, 6, and 7, Your Honor, which relate to the certified mail efforts as well as Mrs. Avers's affidavits. And those are not the substantive materials, but those relate to the motion for default.
Mr. Chairman, again, as explained in the prior hearing, it is up to the commission to determine how to proceed based upon the motion from the state in regard to proceeding or granting the default and proceeding in this matter, whether the commission chooses to adjourn or proceed, grant the default and proceed in this matter uncontested. We submit that motion to the commission now for its consideration.
I'll make a motion that we accept the state's recommendation for default and move that we hear this matter today.
Second.
Got motion second, all in favor, say aye.
Aye.
Opposed, like sign.
Very good. The motion for default having been granted, I remind the commission again about communications outside of the hearing room. And again, Mr. Joseph, do we want to pass out a notice of hearing and charges to the commission for their review?
Absolutely.
If upon review, the commission members discover that they have any outside personal knowledge of this matter, if they would so indicate. member need to disclose any personal knowledge of this matter? Very good. Our technical record in this matter consists of a notice of hearing and charges sent by the state on June 8th, 2012, an order from Judge Collier issued July 6, 2012, returned mail dated July 24th, State of Tennessee's motion to deem service complete and sufficient dated August 3rd, State's witness and exhibit list dated August 7th, and an order of continuance dated August 23rd. Anything additional, Mr. Joseph? We will make this the official technical record, and we will enter into evidence Exhibit 1, 5, 6, and 7 pertaining to proof of service. We'll make those exhibits in this matter. If there's nothing further, you may proceed with your opening statement.
Thank you. Good morning, members of the commission. The state's proof in this matter involving the respondent, Anthony Mazza, will show that Anthony Mazza, and of course, as the record reflects, the state never learned this individual's middle name or middle initial. That this individual was affiliated with a company named Eastern Realty Company of Scioto, Pennsylvania. This individual, our proof will show, came into the state of Tennessee in June of 2010 and personally inspected two subject properties located at 240 and 242 East Main Street, Kingsport, Tennessee. The reports were referred to on the cover page as Consolidated Summary Site and Valuation Reports. The proof from the executive director will show that the respondent has never applied for or received any license or certificate as a real estate appraiser in the state of Tennessee, nor has he ever applied for or received a temporary practice permit. The state's proof will also show that the respondent arrived at a market value of $270,000 for 240 East Main Street and $315,000 for 242 East Main Street, and that he utilized the cost and income approaches, determining the sales comparison approach inapplicable, and that he reported a lengthy discussion of his highest and best use analysis and of his capitalization and accrued depreciation analyses within the income and cost approach. The proof will also show that the respondent referred to himself within these reports as having quote-unquote appraised the subject property, and that the work product was an appraisal and an appraisal report in several places within the body of the report, and that the respondent's name was included in the certification pages as having inspected the properties on June 21st, 2010. The respondent also provided his curriculum vitae and listed many appraisal-related courses at the conclusions of both reports. Further, the proof will show that in this case that there was no information reflecting that these subject properties served as collateral for loans made by a federally regulated financial institution, such that these reports could be considered quote-unquote as evaluations under Tennessee Code Annotated 6239-104. These reports were not evaluations used solely to document collateral or asset value. The respondent utilized market approach and reached market approach conclusions relative to both of these appraisals. Market value conclusions, rather. Finally, the state's proof in this matter will show that the respondent has a very common name on the internet, that the Office of Legal Counsel and the Executive Director's Office have searched for the respondent and come up with nearly 200 persons with the same first and last name. We attempted to locate the respondent at the address for Eastern Realty Company, but he's not responded to the certified mail, or it's all been returned unclaimed, and that the phone number as listed on both of these reports is not reachable. Based upon all of the above conduct of the respondent, which the state submits will be proven by at least a preponderance of credible evidence, the state will request the commission to find, number one, that the respondent's actions in the written reports that he prepared establish that the respondent provided an appraisal and appraisal report as those terms are defined by Tennessee Code Annotated 6239-102, sections 2 and 5. Number 2, that the respondent engaged in unlicensed practice by appraising these two properties in June of 2010 in violation of Tennessee Code Annotated 6239-103A, which prohibits individuals without a license or certificate from engaging in the practice of real estate appraising in this state. Number 3, that the reports which this respondent has prepared were not evaluations, as that term is defined by 6239-104. Number 4, that the Commission has authority under Rule 1255-5-.022 to assess the civil penalty against any person required to be licensed or certified who violates TCA 6239-103A of up to $1,000 for each violation, and each day of continuing violation may constitute a separate violation. And number 5, that the respondent's violations of TCA 6239-103A authorize the assessment of investigatory and hearing costs. In this case, given the documentary evidence that's in the possession of the state, given that we are not able in this case to know exactly how many days the respondent committed violations of the unlicensed conduct statute in Tennessee, we do know at the very least that he personally inspected both of these properties on June 21st, 2010. And his 2 appraisals resulting in these 2 reports constitute at least 2 violations. Accordingly, the state would request the Commission in this matter involving unlicensed conduct of these 2 properties in Tennessee to impose a civil penalty of at least $1,000 per report for a civil penalty of $2,000 and the assessment of all investigatory and hearing costs, because on this record the only thing the state can prove is that the respondent inspected these properties on June 21st, 2010. Thank you.
Thank you, Mr. Joseph. Would you proceed with your witness, please?
Yes, Your Honor. As its first and only witness, Your Honor, the state will call Nicole Labor as Executive Director.
And if you would remember, you've been sworn.
And you are Nicole Labors, correct?
Yes.
And your business address is 500 James Robinson Parkway, Nashville, Tennessee, 37243, correct?
Yes.
You are Executive Director for the Tennessee Real Estate Appraiser Commission?
Yes.
And how long have you served in that capacity, ma'am?
A little over 6 years.
And you are a certified residential real estate appraiser in the state of Tennessee, correct?
Yes.
For how long?
8 years.
As Executive Director, are you responsible for maintaining licensure files for all certified and licensed appraisers and for facilitating the licensing and certification process along with this commission?
Yes.
Has your office, ma'am, ever received an application for licensing or certification as a real estate appraiser from Anthony Mazza?
No.
Has your office ever received an application for registered trainee status from an Anthony Mazza?
No.
Has your office ever received an application for a temporary practice permit from an Anthony Mazza?
No.
Has your office ever been able to determine whether or not Anthony Mazza has been licensed or certified as an appraiser in any other state?
I checked the National Registry from the Appraisal Subcommittee, which is required to maintain a list of licensed and certified real estate appraisers, and his name did not appear from the state.
Has the commission ever granted a license or certificate as a real estate appraiser to Anthony Mazza with no middle initial?
No.
Has the commission ever granted a temporary practice permit to Anthony Mazza with no middle initial?
No.
Are you familiar with the complaint that your office opened against Anthony Mazza?
Yes, I am.
And can you tell the commission and the court as to how that came about?
I received a referral from the Pennsylvania board. They were conducting an investigation, and as part of the documents they received 2 appraisal reports. And since the appraisal reports indicated an address in Tennessee, they referred the matter for Tennessee to determine if there had been any violation of the law.
And what did you understand the allegations against the respondent to be?
Unlicensed conduct.
Can you identify the documents which I've just presented to you?
Exhibit 2 indicates, is the letter I received from Peter Kovach from the Office of General Counsel for the Commonwealth of Pennsylvania. Behind it is, there filled out a copy of our complaint form, with Pennsylvania Appraisal Board being identified as the complainant and Anthony Mazza being identified as the respondent, which includes allegations of unlicensed conduct.
Now, do you maintain true and correct copies of each of these documents within your official complaint file regarding the respondent?
Yes, I do.
And do you have a business duty to do so?
Yes.
Your Honor, we move as collective exhibit number 2, the Pennsylvania Prosecuting Attorney's correspondence referring to the Pennsylvania Board complaint against Mr. Mazza to the Tennessee Commission, along with the enclosed copy of the Pennsylvania Board's letter complaint of a David Moore against the respondent Anthony Mazza.
The documents described by Mr. Joseph will be entered into evidence as collective exhibit number 2.
Now, we're going to take the next 2 exhibits together. Are the 2 reports which I'm now showing you as exhibits 3 and 4 copies of the 2 reports that you received from the Pennsylvania Board?
Yes, sir.
And who did you receive these from, ma'am?
That came along with the complaint from the Pennsylvania Board.
And these, do you keep true and correct copies of these documents within your official complaint file regarding this matter?
Yes, I do.
Do you have a business duty to do so?
Yes, I do.
Your Honor, we would move into evidence as the next 2 numbered exhibits, exhibits 3 and 4, which are a report, consolidated summary site evaluation report of 240 East Main Street, Kingsport, Tennessee, and a consolidated site evaluation report of 242 East Main Street, Tennessee, received by Mrs. Davis from the Pennsylvania Board as exhibits 3 and 4 in this matter.
The reports pertaining to property at 240 East Main Street will be marked and entered into evidence as exhibit number 3. And the report pertaining to 242 East Main Street will be marked and entered into evidence as exhibit number 4.
Thank you. Do all commission members have a full copy of Exhibits 3 and 4? Okay, Mrs. Avers, did you read through Exhibits 3 and 4 when you received these from the Pennsylvania Board?
Yes.
Where, Mrs. Avers, within both of these exhibits, which are Exhibits 3 and 4, can you point the commission to where the respondent's name appears that he personally inspected these properties and performed this valuation?
Turn in the Exhibit 3 to the second to last page of the appraisal. There's a certification that indicates the fifth separated paragraph reads, Anthony Mazza has made a personal visit to the property that is the subject of this report.
Is there any other reference to Anthony Mazza on that page?
Yes, the experience at the very bottom of the page indicates Anthony Mazza Colvin and describes his experience in valuation of real estate.
You can find the same language within Exhibit 4 at the same place?
Yes.
Okay. Turn with me on both of these documents to, even though the pages have no numbers, turn with me to the third page of both of these documents. Do you find Mr. Mazza's name?
Yes.
Where within these two reports, Mrs. Avers, do you find that the respondent, Anthony Mazza, derived a market value for these two subject properties at 240 and 242 East Main Street, Kingsport, Tennessee?
On numbered page number 3, there is an indicated market value as fee simple of $270,000. And there's various value indications throughout the report for a cost approach and an income approach.
Do you find anywhere within the body of both of these reports, which is exhibits 3 and 4, that the respondent referred to this work product as an appraisal or as an appraisal report?
from the back, under value influences, it's identified as a property being appraised and in cases of appraisals.
What number paragraph is that?
14.
What do you find in paragraph 18 on the next page?
Paragraph 18 also indicates the fee for this appraisal or study is the service rendered and not for the time spent on the physical report.
What do you find in paragraph 19?
Acceptance of and or use of this appraisal report constitutes acceptance of the above conditions.
Looking at other multiple parts of this report of pages, you find that the respondent utilizes the term appraisal and appraisal report to refer to this work product?
Yes, there's various identified, there's various places in the appraisal report where it is identified as an appraisal and indicates market value and the two approaches to value which should be defined in the appraisal report.
Did you ever receive any contact whatsoever from the respondent regarding these reports or regarding a complaint your office opened in this matter?
No, I did not.
What did your office do after receiving these two reports from the Pennsylvania Board?
On October 26, 2011, we sent a certified notice of complaint to the respondent at Eastern Realty Corp. to the address identified on the cover of each of these appraisals at Scioto, Pennsylvania.
And this, and that would be exhibit number 5 entered in this matter, correct?
Yes.
And in truth and in fact, that notice of complaint letter was received at Eastern Realty Company, was it not?
Yes, it was.
Did you ever receive any response from the respondent to that complaint?
No, no response from Anthony Mazza.
And you were aware, were you not, of multiple other efforts, both by the Office of Legal Counsel and your office, to contact this respondent, were you not?
Yes.
Looking at exhibit number 7, which is your affidavit, can you please describe to the commission what you did in order to assist the Office of Legal Counsel in attempting to locate this respondent?
The initial was to send a notice of complaint to Eastern Realty Corp. To the respondent, asking him to respond. That was the first attempt made. Subsequently, I searched to see if Anthony Mazza had ever been licensed or certified in Tennessee or had a temporary practice permit to see maybe if I could find another address. I attempted to call the respondent at the phone number listed for Eastern Realty Corporation. And in July of 2012, I made an additional search. I called the phone number, and when I called it, the message indicated the number you called is not a working number. I did a Google search to see if I could identify maybe if we switched companies or if we had a different alternate address. So if you look at item number 11 on the affidavit, it indicates the search parameters. I searched for Anthony Mazza as a collective phrase. I tried Anthony Mazza and Eastern Realty. I tried Anthony Mazza in Pennsylvania, PA. I tried real estate or Anthony Mazza and valuation services and consulting, which was in his experience, he indicated that company. So I searched that as a parameter. The only two viable websites I found references to Anthony Mazza was one internet blog called the Rip Off Report and another called Scam Informer. which I attached to the affidavit when I submitted it. Anthony Mazza I searched yellow pages and white pages for Anthony Mazza in Pennsylvania, and I didn't come up with any like, zero results. I searched the appraisal subcommittee, which is the federal reporting agency, to see if he had been licensed or certified in another jurisdiction. Didn't have any results on that also. And I checked other agencies in Tennessee. I couldn't find an Anthony Mazza listed as a broker or anything else.
Have you, since you opened this complaint file through the present, have you been contacted by Anthony Mazza in any way?
No.
Has your office received any additional complaints against Anthony Mazza after the opening of this complaint?
No.
No further questions of Ms. Avery, Your Honor.
Anyone on the commission have a question?
Ms. Ames, did you try to find out whether this Houston Parish Capital Partnership in New York existed or not? One who she made the appraisal for, supposedly, allegedly?
The clients identified in the appraisal?
Yeah.
I don't recall searching to see if the client existed, since he didn't indicate he worked for them other than as the identified reporting appraiser. I deem it necessary to search that company.
So it sounds like you went over and above what would be considered normal. Commend you for that. I was kind of curious about the other. Sometimes I'm trying to find my letter here from David Moore. As usual, I can't put my hand on it.
It's part of the initial complaint.
Last page.
I have a question. I said, did you attempt to, or did you locate Eastern Realty Corp with any Secretary of State in, say, Pennsylvania or anywhere else?
We did contact Eastern Realty Corp. They acknowledged the letter, but indicated that Anthony Mazza didn't work there.
Did they say whether he'd ever worked there?
They said he no longer worked there.
No longer.
Did I understand you also say that Pennsylvania had no record of an Eastern Realty Corporation being in business or being licensed or being allowed to do business there? Because it's a realty, I was just wondering if the real estate commission would have anything about where they might be, where they're located, and that nature.
We located Eastern Realty Corporation. We were just unable to find Anthony Mazza.
Did this company, Eastern, ever imply that he worked for them at one time or did not work for them at one time?
Yes, they indicated that he no longer worked for them. They were not able to provide me with an address for the respondent.
Any additional questions?
Mr. Jessup?
No additional proof, Your Honor.
Closing statement.
Briefly in closing, members of the commission, the state submits that the proof in the way of Mrs. Avery's testimony as well as the documents that have been entered into evidence establish quite clearly that the respondent, Anthony Mazza, did personally inspect, come to Tennessee, prepare these two reports, which the state submits are clearly appraisals and appraisal reports which violate Tennessee Code annotated provisions that we have cited. This is unlicensed conduct. The state does not know how long he spent on these reports. I think he stated within both of these reports the date of the inspection was June 21st, 2010. At least on that particular day, the respondent engaged in unlicensed conduct. If the commission looks at the second page of these reports, it clearly states that the property was inspected on June 21st, 2010. The respondent could very well have engaged in additional acts of unlicensed conduct, but the state submits that this is evidence of two acts of unlicensed conduct in the state of Tennessee, that these two reports do not constitute evaluations as have been defined under Tennessee law. Given the fact that the respondent has never been granted a Tennessee license or certificate, there is nothing that can be done in the way of a license or sanction since he has no license or certificate. But that the commission does have authority to assess civil penalties for acts of unlicensed conduct against the person who is required to be licensed to engage in the conduct. Up to $1,000 per violation. Based upon the inability to prove any further violations, therefore the state only requested a $2,000 civil penalty and the assessment of costs. Factually, the state would request the commission to review this matter in light of the state's notice of hearing and charges, and would ask the commission to take votes on each of the particular allegations of fact individually. Allegations of fact 1 through 7, which the state believes have been borne out, and it would also request the commission to take votes on specific alleged conclusions of law 1 through 5, as listed within the notice of hearing and charges, which the state submits have been borne out by the proof, and at the conclusion of this proceeding to impose a civil penalty against the respondent, at least in the amount of $2,000, and to assess all investigative and hearing costs against the respondent, which would include the cost of the court reporter as well as the cost of the Administrative Procedures Commission. Thank you.
Thank you, Mr. Joseph. This matter will now be submitted for consideration by the commission based upon the live testimony of the state's witness as well as the exhibits entered into evidence. As Mr. Joseph indicated, you have the notice of hearing and charges before you to be used as a guide for creating your finding of fact and conclusions of law. Again, we need specific statements about the actual facts that you have found to have been proven by the state, and then when you do your conclusions of law, linking those facts to the law at issue in this matter, and then we will also need a policy statement. Again, the state has the burden of proof in this matter to prove by a preponderance of the evidence that the allegations made in the notice of hearing have been proven. And unless there's any questions, Mr. Chairman, we'll submit this matter for consideration by the commission, and we will allow you to proceed with the deliberations.
Thank you, Judge. The first item to be considered is the allegation of fact. The first allegation is made that the respondent is not presently or has ever been licensed or certified as a real estate appraiser in Tennessee, and has never been so licensed or certified in any state. Number 2, that in June of 2010, while employed by Eastern Realty Corporation, Be prepared 2 consolidated summary site evaluation reports of properties located at 240, 242 East Main Street, Kingsport, Tennessee. Number 3, the respondent identified the properties at 240 as being a 6,800 square foot single-story building. The property at 242 East Main, 2,850 square feet on both the ground and upper floors, and arrived at an estimate of value for both of those properties. The respondent utilized the cost and income approaches to value and determined sales comparison approach not applicable in both reports. And the respondent further provided that both reports a lengthy discussion of highest and best use and its capitalization and approved depreciation analysis. 5, respondent refers to this as an appraisal report throughout the reports. And number 6, there was no information within these reports reflecting the subject property served as collateral for loans made by a federally regulated financial institution, or were used solely to document collateral or asset value, or that these reports were evaluations. And finally, number 7, the state used all means to locate and communicate with the respondent. Unfortunately, they were not able to locate the respondent after several and numerous attempts. These are the findings of fact that the Commission has found at this point in time. The Commission is in agreement with that. Signify by saying aye.
Aye.
Opposed, like sign. Now, the next item to consider is the alleged conclusions of the law, the actual law that was violated. And these are items 1 through 4. 1 through 4, 1 through 3. 1 through 3, I believe. And it's alleged that it's in the conclusion of law 62-39-102, unless otherwise reduced in this chapter. Appraisal means the act of developing opinion of value of identified real estate. Appraisal report means any communication, written or oral, of an opinion of value. And number 2, it is alleged that the respondent set forth in number paragraphs 1 through 6 also violate Tennessee Code annotated 62-39-103 (A), which states that it is unlawful for anyone to solicit an appraisal assignment or to prepare an appraisal or an appraisal report relating to real estate or real property in the state without first obtaining a real estate appraiser's license or certificate. It also alleges that the respondent prepared that the reports that the respondent prepared in this matter do not constitute evaluations. So this is also chapter 62-39-104. Chapter does not apply to any evaluation of the value of real estate serving as collateral for a loan made by a federally regulated financial institution, or to any evaluation of the value of the asset of a trust held by institutions. And then there's 3 things in here. However, is my belief, and I think the Commission would agree, that all these allegations of law have been proven beyond a doubt. I get a motion to accept.
I'll make a motion to accept.
Second. Comment? All in favor, say aye.
Aye.
Now, the third thing we have to consider would be the penalty phase of it. At this time, the state has recommended a penalty of $2,000 or $1,000 for each report. And however, I would entertain a motion to either accept that or expand on that motion with something to deal with if this gentleman does ever apply again. We put something in the file to make sure that we're well aware of his past record. So I hear a motion.
So moved.
Question,
Yes, sir.
you said apply again, do you mean if he ever does apply?
Correct, if he ever applies, period. Correct.
Thank you.
I'll second.
Okay. All in favor of the amendment, say aye.
Aye.
Opposed, like sign. All right. Yes, sir, Mr. Joseph.
Just want, what do you think, what do you want said, that he must pay this if he ever applies?
Correct.
Okay. I just
If he
wanna
ever
make sure.
applies, he has to pay this fine
And cost.
and exactly. And then again, it'll still be subject to the commission
Right.
to grant him permission to obtain a license.
Policy statement, and you're done.
Tennessee Real Estate Appraisers Commission is charged with the duty to regulate the practice of real estate appraising and the AMCs in the state of Tennessee, such that the citizens of this state shall receive all such services in accordance with state law and regulations. Because the respondent has violated the law and regulations governing the practice of real estate appraising and AMCs, it is in the public interest of the citizens of this state and for the protection of their welfare that we have fined the respondent $2,000 and have also asked that he should apply for licensing or certifications in the state of Tennessee that be brought to the attention of the commission before his application is acted upon.
This one, did we miss the court? Did we miss the court costs?
Court costs,
I didn't know.
one of our commissioners correctly stated that in addition to the $2,000 fine, also the court cost involved within the proceedings.
Since that's an amendment to the motion, can you do another?
Yeah. Do we have makes the motion, do I have a second? Second, all in favor of the amendment? Aye. Opposed, like sign.
And then we just need a vote on your policy statement.
Okay. Yeah, we need a vote on the policy statement. And all in favor, say aye. Aye. Opposed, like sign. Carried.
Great, thank you all very much. Mr. Joseph, anything further?
No, Your Honor, that concludes all my matters for today.
Great, thank you all very much. You're adjourned.
Thank you. And at this time, Commissioners adjourned.